All right, looks like we're getting a lot of people joining us right now. We're going to start here in just a second. I want to thank everybody for coming today. Hopefully everybody survived the weather yesterday without any burst pipes or car accidents. We've got a pretty big crowd today, and we're going to talk about tips for successful homeowner communication. This one's going to be maybe a little shorter than usual, so we'll have some time at the end to answer questions on this topic, or maybe some other general questions if y'all have them. My name is Cliff Davis. I'm an equity shareholder with Roberts, Markel, Weinberg, Butler, Haley. I've been doing homeowner association law now for about 24 years or so. That's all I do all day, every day. And let's see if I can get the next slide to go down. Kyle, are you there? Oh, there we go. All right, I got it. So some of the things we're going to talk about is digital communications, just talk about trying to share information with the owners, transparency, and talk about following the law when you're giving notices to owners about board meetings, votes, and those types of things. So, I mean, as you all know, some of this is just common sense. The digital kind of is the way forward, where most associations are no longer sending printed newsletters. Most now communications are through digital means. The newsletters cost a lot of money. You had to print them. You had to pay for the mailing. A lot of times people, when they get something in the mail from their HOA, don't look at it. I'm sure you've all have experienced that, including not only newsletters, but demand letters or violation letters.
Hey, Cliff.
So, yes.
Just a second. There's a few people that say they can't hear. Teams was having issues because we had to have Cliff log back in because it was giving him audio problems. I would recommend those that cannot hear sign out and sign back in, and that should fix your issues.
Do you want to type that in the chat or something too, Kyle?
Yes, I will type that in the chat as well.
Okay. A lot of times associations now, and we recommend trying to communicate to your owners by email, some by text messages, and some by social media. And these communications should really be pushing out information. I'm sure that you have all been at a board meeting and an owner comes in and says there's no transparency. We don't know anything that's going on. And a lot of times that's just because the owner hasn't made the effort to find out what's going on until they have an issue. And then they show up and want to tell the board that, the board's doing a bad job on transparency. So the way to combat this is to push out information often, and use email. Obviously, you want to get an email list of all your owners. If you have an email list, you should use it. You should push out information on at least a monthly basis, if not a weekly basis, of what's going on with the association. Some associations have started gathering text messages. Some are using social media like Facebook or whatever platform there is out there. From what I understand, young people don't use Facebook anymore. But if you use social media, it should just be to push out information. We generally advise not using it to allow like a homeowner forum, because typically all that kind of evolves into is negativity and nastiness and arguments. And I think if you've all ever tried to get into an argument on social media, you should all know that no one ever wins those arguments. So if you're going to use these technologies, use them to push out information. There's a lot of the next door type apps out there that owners start a group within their neighborhood, and we generally advise board members that you should not be responding on those types of apps. And some board members will say, well, I wasn't responding as a board member, I'm responding as an owner. The fact of the matter is that if you are a board member and you get into some back and forth on Nextdoor, the owners see you as a board member speaking for the association. If you, and so board members ask me all the time is, well, we're seeing this on Nextdoor. We're not responding, but we're seeing all this. And a lot of it's just misinformation. And in those cases, I think the boards have to make a choice of how do we respond to this? And the way to respond is to push it out through your social media, or even if necessary, to actually send a letter if it's bad enough. And that communication can start out with, we understand there's a rumor in the community of this, whatever that wrong thing is or negative thing is, and say, here are the facts, and lay out what the facts are. Again, you should avoid getting in these back and forth on these forums, because nobody, like I said, nobody ever really wins those arguments. So, you do want to make an effort to share information with the community. So when that owner does show up at your board meeting and says, we don't know anything, you don't share any information, you can say, well, are you on our email list? If you are, we sent emails out on this date, and this date. This is the information that they contained. We have a Facebook page that we update, it was last updated 2 days ago with information. So, and just, I don't mind telling owners, look, this is not the association's sole obligation to get information for you. It's also your obligation as an owner to try to find out what's going on in your neighborhood. And you can take that position as long as you are, in fact, putting information out there, and the owner just has to determine how that's coming. Do they need to register their email? Do they need to know about your social media page and access it themselves too? It's kind of a back and forth. So one thing that we want boards to remember is that the board can take action between meetings by an email vote on almost all aspects of association business. However, all board members and all managers should keep in mind that there is a list of 15 items on which the board has to consider and vote on in the open session of a properly noticed board meeting. If you're a board member listening, the one thing you should take away from this webinar, if anything, is to know that there are these 15 items that have to be done in the open session of a properly noticed board meeting, and to know that you can't vote on these types of actions by email. And some of them are a little counterintuitive. For example, the initiation of foreclosure actions, initiation of enforcement actions. Typically what this means is that when you are going to turn a matter over to your attorney, that decision must be made in the open session of a properly noticed board meeting. And you'll hear me say that phrase a lot, the open session of a properly noticed board meeting. And we'll talk about notice here in a second. So that should be an agenda item that when you send that meeting notice and agenda, that the board will consider and vote on turning owners who are delinquent on paying assessments over to the attorney to take collection action, including lawsuit and foreclosure if necessary. And then there's ways to do that, to vote on that, and to do it in the open session without disclosing the owner's name or address, which you don't want to disclose in the open session. So a couple of those methods might be, you might use an account number. Most management companies assign an account number to an owner's account. And so you would say, a board member would say, I'll make a motion to turn account 1, 2, 3, 4, 5 and 6, 7, 8, 9, 10 over to the attorney's office to collect delinquent assessments and other charges through for lawsuit and foreclosure if necessary. You can use an account number. For collections, you can use an account. A board member would make a motion. I make a motion to turn over any owner who has a balance of more than $500 over to the attorney, like I said, for collection of the assessments and charges through lawsuit and foreclosure if necessary. And the reason that is important is because at some point, if you file a lawsuit, the owner, or more likely the owner's attorney, is going to contact the association's attorney and say, show me where the board approved this in the open session of a properly noticed board meeting. And when that question comes, you should be able to pull out board meeting minutes that say, on this date, the board voted in the open session to turn account number 1, 2, 3, 4, 5 over to the association's attorney to file a lawsuit to collect. Your client's account number is 1, 2, 3, 4, 5. So you can show that it was done properly, that it's noted in the meeting minutes. If you cannot do that, if you can't show that it was done in the open session of a properly noticed board meeting, there's a chance that you may not be able to cover the attorney fees, or they may be able to get the lawsuit dismissed because the law was not followed. Kind of another odd thing on this list is ACC appeals. So when an owner appeals the denial of an ACC application, an architectural control authority, or whatever you might call it in your association, When they appeal that decision by that control committee to the board, that hearing by law should take place in the open session of a properly noticed board meeting. And I think a lot of associations either don't follow this practice or may not be fully aware that this is what the law requires. As a practical matter, I think most owners probably don't want to air this out in front of everybody. So if the owner agrees that it can happen in the executive session or it can happen in a hearing before the board outside of, that's not a problem. But if you're not doing it in the open session of a properly noticed board meeting, you need to make sure that you have some kind of documentation, which typically is going to be some email chain where you advise the owner, can we do the hearing during executive session? Do you agree that that's okay? Or can we do the hearing on this date? It'll just be in front of the board. Is that okay with you? And as long as they agree to that, then that's not a problem. But again, everybody should be familiar with these items and understand that they all must be considered and voted on in the open session of a properly noticed board meeting. My favorite phrase. So let's talk about board meeting notices, or just meeting notices in general. If you're going to mail a board meeting notice, it has to be mailed at least 10, not more than 60 days before the board meeting. As a practical matter, there's no associations anymore that really mail notice of board meetings. Most of them use the other two notice methods that you can use. So for a regular board meeting, it's 144-hour notice, meaning the notice has to go out at least 144 hours before the start time of the meeting. And you can give that notice by posting it on your website and sending an email to everyone who's registered an email address. That notice should include the meeting agenda. So when you post it on your website, it should be a meeting notice that includes the agenda. When you send that email, it should be a meeting notice that includes the agenda. The other way to do it is put signs on common area or on private property if you have an owner's permission of when the meeting is going to be, and send an email to everyone who's registered their email address. I think probably the best way to do this is a lot of associations do both. They put it on their website. They might put a sign up at the entrance to the subdivision, and they send the email. And again, for a regular board meeting, it's a 144-hour notice requirement. And for a special meeting of the board, it's a 72-hour notice requirement. So all boards should be aware of these notice requirements and make sure that they're being followed when you do have a board meeting. Let's see, what are we talking about here? Again, just what's on the notice is inform the unit owner of the time and place of the board, regular or special board meeting. Typically the association representative is going to know when that happens. So really this is just more common sense. Make sure that your notice includes everything. Should say the name of the association, the legal name of the association, date, time, and place of the meeting, and comply with the notice requirements of the property code. Collection policy. Collection policies are not required by law, but we generally recommend that you have a collection policy out there that you can point to when an owner asks, how did this happen? What happens before you turn my account over to an attorney? And the policy should talk about the due date of the assessments. Notice that cost of collection are going to be collectible against the property. Late fees, if applicable, will be applied. A general description of the letters that may be sent. So, I see a lot of collection policies typically that are prepared by board members, and no offense, but a lot of them sometimes can be prepared by retired engineers who, just because of the way they work, have this incredible amount of detail in the policy. On February 2nd, we will send this letter. On February 20th, we will send this letter. On March 15th, we'll send the 209 letter. You don't want that level of detail in your policy. A lot of times what that does is it just sets up the association to violate its own policy by missing some deadline in the policy. We recommend that your policies be on this issue, be a little more general, saying that, the association may send one or more courtesy notices of the delinquent amount. The final letter that will be sent will be what's called the 209 collection letter, and that's a letter that complies with Chapter 209 of the Property Code. For collections, it's Section 209-0064, and that letter has to have some specific information in it of what the owner's rights are and how much is due, and we're going to talk about that. So with the collection policy, that's typically something that, excuse me, unless your documents say otherwise, the board can adopt without having a vote of the owners involved. So we do recommend that you have a collection policy that lays out kind of the procedure in general, not specifically. Board meeting, make sure it's properly noticed, make sure a quorum is present, which is typically a majority of the board. Excuse me, I got a little cough going. And no matter what type of policy it is, if a collection policy or any type of rules or regulations or guidelines, keep in mind that those constitute a dedicatory instrument of the association. Another term for that is a governing document. And all governing documents, all dedicatory instruments must be approved by the board in the open session of a properly noticed board meeting. That's one of the items that's on that list of 15 things. And anytime you're adopting a collection policy or any other type of policy, you also want to make sure you take a look at your governing documents, your declaration, your bylaws, your articles of incorporation, and make sure that they don't address the subject matter of whatever the policy that you're doing. Because when you adopt a policy, it should not conflict primarily with your declaration is what you're going to be looking at. If it does conflict, the declaration controls. So let's talk again about that 209 collection letter. Again, it comes from Section 209.064 of the Property Code. That letter has to be sent by certified mail. You have to give the owners 45 days to pay. You have to tell the owner that they have the option to get a payment plan. The letter should mention that they are going to be responsible for attorney fees if they don't either pay in full in 45 days or contact the association for a payment plan. If your 209 collection letter includes language that says that you're going to suspend their usage rights of the pool or whatever other common area, that 209 collection letter also has to include language that the owner has the right to request a hearing before the board. They have 30 days to request that hearing, and it has to include some military notice language. So those last three things that are in italics are requirements if your collection letter includes a threat that you're going to suspend usage rights of the association's common area. If you're not going to suspend usage rights, that language is not required by law to be in there, but I know that some associations put the right to a hearing in their 209 collection letters, even though they're not going to suspend usage rights. That's just a decision that some management companies make, a decision that some boards make. In that 209 collection letter, we recommend that it include an itemization of the total amount due, not just an amount. We believe, and the law is not crystal clear, but we believe the intent of the law is that it include an itemization. So either attach an account history, or in the body of the 209 letter, have an itemization that specifies each delinquent amount by class. So assessment, and if there's more than 1 year assessment, we think it should be itemized to the point where it says, 2023 assessment, this amount, 2024 assessment, interest, late fees, whatever other charges that might be on the account should all be itemized. Again, if you don't send that letter by certified mail, you may not be able to recover your attorney fees. And remember that cure period is 45 days. Initially, the law required 30 days. That was changed a couple of legislative sessions ago. But every once in a while, we will still see a 209 letter come through our office where they haven't made the change, that it's 45 days for the owner to cure the delinquency. So make sure that your 209 letters are up to date. It has to offer a payment plan. So by law, the association is required to offer a payment plan unless the owner has defaulted on a payment plan in the previous 2 years. if that is the case, you don't have to offer a payment plan. I think probably as a practical matter, most associations do offer payment plans, and we generally encourage associations to offer a payment plan, even if there has been a previous default. There's always exceptions to this rule, depending on who the owner is. If you've got a serial delinquent owner, there may come a point where you say, we've offered you 3 or 4 payment plans in the past. You've defaulted on every one of them. You're not eligible for a payment plan this go round. It has to describe the options the owner has to avoid having the account turned over to a collection agent. And those options are pay in full or get on a payment plan. And generally in these letters, just you try to keep it simple. I mean, we think the letter should say, you must pay the full amount due in 45 days or contact the association to get on a payment plan in 45 days, or you will be turned over to the attorney. Sometimes we get collection letters that we don't think are really crystal clear in describing those options and letting the owner know this is what you must do in order to avoid being turned over to the attorney, which the law says collection agent. That could be an attorney is a collection agent, a collection agency is a collection agent. Though I know it sounds self-serving, we generally don't recommend against using collection agencies just for a number of reasons. So let's talk about a 209 letter for a violation. So the 209 collection letter is primarily governed by section 209.0064 of the property code. The 209 letter for a violation of the deed restrictions, and in a couple other instances, is governed by section 209.006 of the Texas property code. So for a violation letter, the 209 violation letter must describe the violation that you're complaining about. And the biggest issue here is that a lot of times, and we see these letters and we've heard owners complain about these letters, is that they get a violation letter and they read it and they can't tell really clearly what the violation is. And so we're always encouraging management companies and boards to make sure that the description of the violation is such that anybody can look at it and determine exactly what you're talking about. If you say remove the mold and mildew from the residence, and it's all the mold and mildew is on the right side of the residence, say remove the mold and mildew on the right side of the residence when facing the residence from the street. And anybody should be able to read that and say, if I'm looking at my house, they're telling me there's something on the right side of the house. So whatever that violation is, make sure that the description is clear enough so that a reasonable person can look at it and know exactly what you're talking about. I know that there are some management companies and associations that actually include a picture in their letter, in their 209 violation letter. The violation letter should state any amount due the association from the owner and inform the owner that the owner is entitled to a reasonable period to cure the violation. And if there's a fine that's being levied, there has to be some language about the fine amount. And the 209 letter must say, if it's a curable violation, meaning like if it's a paint house or get the car out of your yard that's on blocks, and you want to fine them for that, and you have fining authority, the letter has to tell them you're going to be fined $100 if you don't cure this violation, within 30 days of the date this letter was mailed. So you've got to give them a time to cure the violation if it can be cured. And if you want to fine them, they can avoid that fine by curing the violation within the time frame you give them. You have to tell them that they can request a hearing before the board. And they have to request that hearing in writing on or before the 30th day after the date the notice was sent by the association. You have to tell them that they may have special rights under the Service Members Civil Relief Act. And this provides some rights for owners who may be on active military duty. If they request a hearing, you've got to schedule that hearing not later than the 30th day after the date you receive the request, and you have to give the owner at least 10 days written notice of the date, time, and place of the hearing. That hearing should be held before the board of directors. Now, the problem is, you send a 209 letter, you get that request, and it starts this timeline ticking. And sometimes it can be tough to meet that deadline, depending on maybe when your next board meeting is, or for other reasons, you're late in informing the owner when the hearing is going to be. In those cases, you can always set the hearing for a later date if the owner agrees to it. So if you find yourself bumping up against a deadline to get a hearing held that the owner has requested, you can contact the owner and say, will you agree that we hold the hearing on this date, which may be past 30 days of the required date? And if the owner agrees to that, you're good. So, generally, any of these requirements of the law, if you come to an agreement with the owner on the issue, then you're good, and you can have the hearing outside the time constraints of the property code. So on these violation letters, the law now requires that you've got to provide the owner with a hearing packet containing all documents, photos, and communications that the board intends to show to the owner at the hearing. And this should be everything you have. So the owners, generally what this is saying is all the evidence you have, you need to provide it to the owner. So if all the pictures you have, most associations will provide a copy of the deed restrictions and say, here's the restriction you're violating. Here's the letters we sent you. Here's the pictures that we have. Here are some communications that might be from other owners that are complaining about the violation. If you have those types of communications, we generally believe that you can redact the name of the owner making the complaint. What you don't want to do is have some violating owner go out and retaliate against an owner that made a complaint. At this stage, we think you can take the position that you don't have to tell them who did that. If a deed restriction violation goes to trial, any owners that have submitted complaints need to understand that you will not be able to shield them at a trial, that they will, you'll have to give them, their name will be given to the complaining owner. A lot of times owners want to make a complaint, but they don't want to get involved. But if they do submit something in writing, you can take the position that you can protect them before a lawsuit. But if a lawsuit is filed, you cannot. The owner is going to find out who made that complaint. And when I say you can take the position that you can not disclose their identity before the lawsuit, an owner may, when you refuse to give them the name, file an open records request and ask a court to require that you give them that communication with the owner's name on it, and a court may require that happen. But that's something that we feel comfortable in telling associations, look, you don't have to give them the names of the complainants, but just be advised that if a court issues a court order, you're going to have to. A lot of violators aren't going to go through that trouble and expense prior to a lawsuit to do that, but there is that possibility. So at the hearing, the board should present its case first. So the board should say, we noticed there was this violation. Here's the letters we sent you, and present all the evidence and let them see that you, and again, they should already have all that. The owner can then kind of respond and see if you can come to some kind of conclusion without getting your attorneys involved. The purpose of this whole law that passed that gives the owners the right to a hearing was to try to get owners and boards together without the involvement of attorneys. As a practical matter, a lot of times now, an owner may bring their attorney to their 209 hearing, or it may be so contentious that the board wants the attorney to show up there anyway. So I'm not sure that it really has taken the attorneys out, but that was the intent of the law. When you set that hearing date, either party can ask for a postponement of more than 10 days. And again, this can be difficult because, the board members are volunteers. They're typically committed to coming to the board meeting each month or whenever those are held. And when you start setting hearings outside the board meeting and then a party wants a postponement for 10 days, it can create some scheduling issues. So again, if you can't do it within the constraints of the property code, the best advice is then to try to get an agreement from the owner on when that hearing will be so that everybody can plan to be there. Additional postponements of the hearing can be granted by agreement of the parties, and the law allows that either the owner or the association can record the meeting. And we know that can sometimes make people uncomfortable when any type of a meeting is recorded. But in this instance, the law does allow either party to make a recording of a 209 hearing. Keep in mind also, we talked about pushing out information. The law now requires that every association of at least 60 lots or any association that has a management company maintain a website that's available to the members. And the law requires that, and this right now, this is for single family only, non-condominium developments. The law requires that the website have a copy of all current dedicatory instruments. So your declaration, amendments, your articles of incorporation, your bylaws or your certificate of formation, any rule, policy, or guidelines you have, current copies of all those documents should be on your association maintained website. Most of the time, this is something that if you have a management company that they're going to maintain, but we do represent a number of self-managed associations that are more than 60 lots. And in that instance, they have to make sure that they are maintaining a website and make sure that their governing documents, their dedicatory instruments are posted to that website. Oh, wow, we're already at the end. So again, try to get information out as much as you can, so you can avoid that allegation that you're not being transparent. And again, like we said, most of the time, a lot of the time, it's just the owners not making an effort to be transparent to find out the information. So have that website, make sure it's updated, make sure your governing documents are on there, all current copies of your governing documents. If you have a social media page, make sure that it is not just something that's there, that it is also being updated with information. Push out those emails to everybody who's registered an email address to let them know what's going on, so that when that owner does make that allegation, you can say, here's our website, it's current, here's our social media page, it's current, here's the emails we sent, that this is a two-way thing. You have to make an effort too. Be cautious in what and how information is shared. And that's why I say when you push out information, push out factual information. Avoid those message boards where people get in these ridiculous arguments that no one ever wins. And when you're communicating your board meeting notices, your 209 letters, make sure that you are following the law, that your letters are compliant, that your notices are compliant, that your notices have an agenda, that give owners an idea of what you are going to talk about in those board meetings. Keep in mind that the law does allow a board to go into an executive session during a board meeting. There's a provision in the property code that talks about the items of what can be discussed in executive session. Board meeting discussions in executive session should be limited to those items. They're generally, with maybe a few exceptions, decisions really shouldn't be made in executive session. Decisions should be made in the open session. And kind of a common mistake I see talking about executive sessions is that in order to have an executive session, you first have to call to order an open board meeting. I see associations and they say, we want you to come to our board meeting. We're going to start with an executive session and then we're going to have an open board meeting. And I tell them, you can't have that executive session unless your meeting notice says the meeting starts at 6. We are going to immediately adjourn into executive session. The open session will start at 7. So that way, and owners, you're communicating to them, we're going to have a board meeting. It is open to you. However, be aware that as soon as we open it, we're going to go into executive session and the public open session will start at 7. So that tells them what you're telling them is you should really come at 7, because if you come at 6, you're going to get kicked out of the room when we go into executive session. And so just keep that in mind, that in order to have an executive session, you first have to call to order an open board meeting. That is all I have except for questions. You can type a question into the chat and we've got some time to answer questions. Kyle, I can't see the chat. or maybe this is it. I don't know if we have any questions.
Oh, we got a ton of questions.
We got a ton of questions. All right, here,
I can just read them all. I can read them all
okay.
for you if you want me to.
Okay.
All right. So let's just start at the top. So do we need the homeowner's permission to use homeowners' email addresses to receive info from the board?
Read that one again. Do we
Does the board need a homeowner's permission to use their email address to receive info?
to receive information from the owner?
To receive information from the board. So the board wants to send communication out via
Oh,
email. Do
yes,
they need?
I would. I mean, I'm not sure how you would have an owner's email unless they gave it to you. So, yeah, I would not put an owner on any kind of a group mailing list unless you've solicited emails and the owner has provided those emails to you. And obviously, even if you have an owner's email and they say, take me off this list, you need to take them off the list. I hope that answers the question.
All right. Next question. Going back to the open meeting 15, what about an appointment of a board member to fill a vacancy that came up? Is
that is one of the things that has to happen in the open session of a property notice board meeting. So your agenda item would say the board will consider and vote on appointing to fill a vacancy on the board. What I advise associations is that anything that you're going to vote on, your agenda item should start with the board will consider and vote on. And that tells the owner this is going to happen. You know, I see a lot of agendas where it just says vacancy on the board. And that probably is enough to get you there. But, I think in the interest of transparency, your agenda item should say for anything you think you're going to vote on, the board will consider and vote on blank. And if you have a discussion or the board determines that that's not going to happen, you just have to pass on that agenda item or table it till the next meeting. But let the owners know this is going to happen. The board will consider and vote on hiring ABC Landscaping. The board will consider and vote on appointing to fill a vacancy on the board. The board will consider and vote on the election of officers.
All right, next question. If the HOA has an approved policy, I'm assuming this is referring to a collection policy, when the homeowner reaches X dollars, it will be turned over to collections. Do they still have to ID each account in a meeting?
I meant to address that, and so I'm glad that whoever asked that. So in our collection policy, that the one that I use primarily, there's language in there that says that the board, by the adoption of this collection policy, the board or the manager can turn an account over to the attorney for collections. And it's important, whether in the policy or in the motion, that it include that language through lawsuit and foreclosure if necessary. We know of one case, it was an out-of-state case that has a similar law that it had to be done in the open session. And the board voted to turn it over to the attorney for a lawsuit. And the association foreclosed, and the owner challenged it, saying the board just turned it over for a lawsuit. They didn't authorize foreclosure. And the court said, you're right. But anyway, back to the question. We have language that authorizes the board to do that by the adoption of the collection policy. For me, primarily, that's kind of a belt and suspenders that the board can point to in the event that it failed to properly do it at a meeting. There is no case in Texas that we're aware of, and the law is not clear on if putting that language in the collection policy is enough. So the most conservative advice is to do it in the open session of a property notice meeting. But I would recommend that it be in the collection policy also. Like I said, for me, primarily, it's a backstop if you didn't do it properly per the statute. So I think there's probably some attorneys in the industry that will tell you that is enough. To me, it's better than nothing, but why risk it? It's just easy to do in the open session of a property notice board meeting.
All right, next couple of questions that people asked, referring back to that open meeting 15. What if the HOA is still under declarant control? Does that apply?
So that's a good question too, and I should have made that point. That doesn't apply while the association is under declarant control. A lot of the provisions of the property code don't apply while the association is under declarant control. If you're under declarant control, the one time that it does apply, there's 4 instances, and really the 2 important ones are the adoption of a dedicatory instrument. So if you're going to adopt a policy or a governing document, even under declarant control, that should be done in the open session of a property notice board meeting. And the other time is if you're going to raise the assessment, that has to be done in the open session of a property notice board meeting. I think the other one is if you're going to change voting rights of owners, which typically that's not something that really happens that often.
All right, we're going to go back to, it's not collections, but this time it's fines for the open meeting. I know we had some issues with this one the last time we discussed this.
Okay.
So to clarify fines, a vote
Fines.
on fine
Yes.
removal or waiver for I'm assuming they have a fine policy in place.
So with regard to fines, we generally advise clients, first off, that you can't fine unless you have fining authority in your documents, preferably in your declaration. If it's not in your declaration, then in the bylaws, and let's just talk about what those two documents are. The bylaws are the administrative rules under which the association, which is probably going to be a nonprofit corporation 99.9% of the time, operates. Sometimes we hear board members talking about enforcing the bylaws, and really what they're talking about is enforcing the declaration or the CCRs. The declaration, also called the CCRs, also called the deed restrictions, are the rules of what you can and can't do with your property. The bylaws are the administrative rules for the corporation. So we believe you should have fining authority in one of those documents. If it's in the bylaws, it might be subject to being challenged as to being outside the scope of the bylaws, but better there than nowhere. We don't believe for non-condominiums associations that state law gives the association the right to fine someone. So the first question is, do you have fining authority? And as with any question, you start by looking at your governing documents. And then you look at the property code to see what it says about that type of authority. So if you have a fine policy in place, one of the 15 items on the list is before you can levy a fine, that has to be done in the open session of a property notice board meeting. Now, I have seen some fine policies that, similar to collection policies, have some language in them saying that because the board has adopted this policy, it can fine. It's the same warning there is maybe the law's not clear on that if it's just in the policy. The best advice is to do it in the open session of a property notice board meeting. And if you levy fines in the open session, it's the same thing. A motion was made to fine account 12345 $100 for failing to remove the car parked in their yard. We think it has to be that specific. So when the owner or their owner's attorney comes to us and says, show me where the board approved this fine, in the open session, you can pull out those meeting minutes, say, this is your account number. This is the violation for which you were fined. This is the fine amount.
Right.
If there's a question on removing or waiving fines, that decision does not have to be made in the open session. If the board, has a hearing and the board believes, all right, we're going to waive this fine. Really what that becomes is a decision made between meetings, which also should be recited orally at a board meeting and an entry made in the meeting minutes. So, in that case, it would be between meetings, the board decided to waive the fine on account number 12345.
All right. Next question. I think you did cover this back earlier in the session. Can you do collection or deed restriction files in the executive session and recap once you can reconvene in the open meeting?
So those files should be discussed in the executive session because you're talking about individual owners, how much they owe, and violations. So you don't want to talk about those things in the open session, but the vote on pursuing those should occur in the open session, using the account number, or for collections using an amount. There's a couple ways to do it. I have a memo that I provide to managers all the time on how to document your agenda, which I recommend that there's, if you have finding authority, 3 standing agenda items that are on the agenda every month. And, those are The board will consider and vote on turning over delinquent owners. The board will consider and vote on turning deed restriction violations over the attorney, and the board will consider and vote on levying fines on owners who are violating. That's kind of paraphrasing what that agenda item is on every month's or every board meeting agenda. And those decisions, though they can be discussed in the executive session, should be made in the open session.
All right, next question. Should an association have a homeowner forum at board meetings? And if so, should the board just listen to the questions and respond later, or should they answer questions in real time?
We recommend that at every board meeting, anybody who any owner that shows up at that board meeting should have a chance to speak to the board. And that can be a question, a comment. Some associations do it at the beginning, some do it at the end. What you're not required to do is we see a lot of boards who kind of lose control of a meeting because they get in this back and forth during the meeting with owners. You don't have to do that, and you shouldn't do that. All that does is make your meetings much longer than they need to be. Owners have the right to appear at the board meeting and listen to the association, to listen to the board discuss association business. They don't have the right to participate in that discussion unless the board gives them that right. But having said that, there should be a homeowner forum period, whether at the beginning or the end. You can limit it to 3 minutes a person and let them get up and say their piece, ask their question. If they have a question that you can answer, you should answer the question. There's nothing that infuriates an owner more than to ask questions and the board not give an answer. Boards sometimes can become too defensive about a question, and it may be a controversial question. It may be a thorny question. But if the board has taken a position, you need to assert what your position is on that, and tell them why. And hopefully it's reasonable, and it might not be something they want to hear. But again, this is all about, transparency with the owners. If they have a question you can answer it. If they have a question that you don't know the answer to, tell them that you will get them an answer. And then more importantly, follow up and make sure that they get the answer. I have some boards that they write down every question an owner asks, and they answer what they can, and then afterwards they email blast every question and the answer to every question to every owner who's on their email list. So you really want to try to answer the question if you can.
All right, next question. Does an annual meeting have to have mailouts, or can it be done via email and signage?
Generally, it needs to be mailed. And that's probably what your bylaws say, is that it has to be mailed to every owner. Now, the law does allow, if the owner agrees, for alternative forms of service, which can be email. The issue I see with that is that it can become, unless you're a very small association, kind of a bookkeeping nightmare of who's getting email notice, who's getting a mailed notice. But if the owner agrees to that, you can do them by email. Again, it just creates some practical problems, for your manager of keeping track of who's getting notice and how.
Okay, next question. All right, can you give a general overview of how an ACC appeal should be handled during an open session board meeting? Who gets to speak and in what order?
So I think that the way you would do it is the association would say, the board would say, we've got an appeal, this owner, and you can name the owner and say they've appealed a decision by the ACC for their paint color. We will let them speak and, give us the information they want to give us. And again, if you've got let's just use that example. If you've got a approved paint list that prohibits sky blue and they painted their house sky blue, you can say that they've submitted an application to paint their house sky blue. Section 4.6 of our architectural guidelines prohibits that color. It was denied. But the owners want to appeal that. We'll listen to what they have to say. We'll respond and clarify any facts if necessary. And then you hear the owner out. And, if it's that clear cut, the board can take a vote right then and there on what their decision is going to be. And the board has the right on an AC appeal to overturn it, to grant a overturn it with contingencies, overturn it outright. The board can do whatever it wants to with that appeal. Obviously, the board shouldn't do anything that violates the restrictions when they make a decision. So if the restrictions specifically say you can't do something, the board cannot, the response to that appeal can't be, well, even though it says in the restrictions you can't do that, we're going to allow it. Assuming, of course, you don't have a variance authority. So really, it should just be straightforward. The board can explain, give a brief background on what's happening, let the owner speak, let the board ask questions, and if possible, right there to make a decision, make a decision.
All right, I'm going to jump ahead real fast too, because next couple of questions talk about that subject. For the hearing, does the board need a quorum?
Yes, I think you should have a quorum of the board because it's going to be a board decision on that. If that's going to be a problem, that's something you should discuss with your attorney on if you're going to have a problem getting a quorum of a board to be at a hearing. I mean, obviously, if it happens at the board meeting, you've got to have a quorum to have the board meeting so that they'll be there.
All right, and then to follow up, this person asks, 209.007 requires evidence the association intends to introduce, and that's in quotations. So that's not all known evidence, correct?
Right. I think, though, really what the law is trying to say is you should show them everything you have. I'm not sure if you think there's something that you want to hold back on at a hearing. I would definitely discuss that with your attorney as to what it is and why you think that shouldn't be presented.
All right, I'll take this question. Everyone that's here today will receive an email copy of the slides. We also had this, of course, approved this morning for 1 hour of credit per CMCA. So certificates will go out as well, and the video recording will be posted on our website and YouTube channel within the next week or so. All right, next question. Can an owner come into a regular board meeting and record the meeting at any given time?
So this is a big point of controversy. Like I said, recordings can make people uncomfortable. It can make board members uncomfortable about what they say. It can make owners uncomfortable about speaking freely. If you're going to prohibit recordings at a board meeting, I think you need to put a policy in place and say, recording's not allowed. If you're recording the meeting, you'll be asked to leave. If you're recording the meeting and you're asked to leave and you don't, then we're going to call law enforcement to remove you from the meeting. The problem is now it's the recording devices, phones, somebody just set it on their chair or whatever, or have it out in their hand, and you have no idea it's recording. But I've been to plenty of meetings where an obnoxious owner, brings their iPad in, they're holding it up, recording the board. Like I said, I think it stifles, it may stifle discussion because nobody likes having a camera in their face. But if you're going to prohibit it, you need to have a policy in place. We have a couple boards that record their meetings and send out the recordings. And a couple boards, that was their answer to owners trying to do that, is say, we're going to prohibit the owners from doing it, but we're going to record it and we're going to put out the entire board meeting. The fear was that owners take recordings of these meetings and then they start taking things out of context. And putting out just snippets of things, which sometimes can be harmful or misleading to owners. And that's something you want to avoid.
All right.
But the law doesn't address that, just to be clear. On a board meeting, the law doesn't say an owner has the right to record the board meeting.
We'll say it's legislative session started last week, so contact your legislator if it's an issue you're concerned with. All right, what rights does a property owner have in regards to attending board work sessions outside of a board meeting?
I don't necessarily think they have the right to attend a workshop unless it's an open workshop. And a word about workshops is owners see those as the board conducting business outside of the open session of a property notice board meeting. And unfortunately, we find a lot of times that's what the board's doing. We generally discourage the use of workshops consistently. I mean, I understand that during budget season, it might be necessary to have a budget workshop to try to get all the issues out in the air. But I'd tell boards, look, owner's going to see you. Owner's going to see this as you trying to do business in private. Try to avoid workshops unless it's just absolutely necessary on an issue. But they don't have the right to come to a workshop. And keep in mind that at a workshop, there should be no voting going on.
All right, we got about 5 minutes left, Cliff, so I'm going to try to get through as many of these as possible. Candidacy forms for single-family HOAs. Is there a lot size where these must be sent to all, or is it applicable for all single-family HOAs, no matter the size?
Candidacy forms?
I think it goes back to the example of the website is, say, for an HOA 60 lots or less, do they need forms sent to everyone, or no matter the size, does everybody need a form? I'm assuming.
They might be talking about soliciting candidates because it says candidacy forms.
Yeah.
If you're talking about soliciting candidates for an election, I think it's if you've got 100 lots or more, the law requires that you solicit candidates. And it doesn't necessarily have to be mailed to the owners. That's one way to solicit candidates, but you can do it kind of the other ways too, is put it on the website, an email blast, a solicitation out to everybody, or put up signs and send an email blast. Hopefully that's what you're talking about. But no matter what size you are, if you're going to run, when you have an election, you need to communicate to all owners, hey, we're having an election. You want to submit your name as a candidate, whether it's required by law or not. Again, that's another thing just of openness and transparency, is give everybody the opportunity to submit their name for an election, and don't try to control who is or who knows about the solicitation.
All right. Next question, is Town Square sufficient in place of a website?
Yeah, I think a lot of management companies now are coming up with these platforms that they're using. And as long as every owner has access to that should be sufficient. The only time that might be an issue is that if you have a fining policy, your fining policy has to be on a website that's accessible to the general public and to the owners. So, if you have a website and it requires a password to get into it, that's for a fine policy, that's not going to work. It has to be somewhere where the general public can access your fine policy on the website.
All right. Should meeting minutes be pushed out via email or uploaded to a website?
I think both. When you have meeting minutes, I know a lot of boards wait until the next board meeting to approve those meeting minutes. And sometimes you'll get owners between meetings saying, hey, I want to see the board meeting minutes, or complaining that we never know what happened at the previous board meeting, until after the next board meeting when the minutes are approved. The law doesn't require that board meeting minutes be approved at a board meeting. I've been trying to encourage associations to approve them by an email vote between meetings, and then get them out there quicker. But once they're approved, I would put them on your website if you have one, which you should, and also send an email blast. Again, you can't get an owner to complain that you're not making the email, the meeting minutes available if you're sending an email to them a few days or whatever, a week after the board meeting with the approved meeting minutes.
All right. I know we got 1 minute left. Let's see. Somebody is asking about agenda templates for meetings. Is that something that's available?
I don't think we have one that we just put out there. But if we represent you and you have your manager contact us, or I review kind of form agendas and notices all the time. And when I see one that I think needs a little bit of work, I'll make some suggestions on how to make it better, or what I think is better.
There's a lot of other questions here, Cliff. I think since we are at time, your call if you want to keep going, or I can download these questions and send them over to you.
We can let's answer a couple more.
Okay. I'm just going to skip through here. Is it okay if the community manager from the POA, rather than the POA president, lead a board meeting via announcing, for example, announcing each agenda item, and then the directors discuss and act on them?
Yeah, I think generally that's fine if the board agrees. My experience is that most of the time, or in a lot of cases, the manager actually runs the meeting. I've seen an objection before where somebody says, well, in the bylaws, it says the board president has to preside. The way that I write bylaws says that, the president shall preside. However, that can be given to another board member if the board agrees, or the property manager can be allowed to run the meeting if the board agrees. I really don't see an issue with the property manager running the meeting as long as the president agrees or the board agrees.
Here's an interesting question revolving around virtual meetings and the taking of minutes. Is it okay to use the Zoom or Teams transmission for, or the transcription?
So like you're recording the meeting and then creating the meeting minutes from that recording.
Yeah.
I think that's fine, but just keep in mind that if you record meetings, or whether it's in-person meetings or you're using Zoom or whatever Teams and you're recording them, that recording is an association record. So if somebody presents a proper records request and say, I want to see the recordings of all the meetings, and you're keeping the recordings, you have to provide them to the owner. For whatever reason, a lot of associations don't want to do that. And, it may be the same thing as somebody might take a snippet of that recording out of place. So if you're recording them and you're not intending to keep those as a record, you need to destroy the recording after you make the meeting minutes and not keep it as a record. But I don't see a problem with going back and listening to that and creating the meeting minutes from a recording. It just really becomes an issue of, are you going to keep that recording or are you going to destroy it? It's just for the purposes of making the meeting minutes.
All right. Is forced maintenance considered an enforcement action that needs to be approved in an open session?
There's a debate in the industry about this. So usually forced maintenance is under some self-help provision in the deed restrictions, and typically it's a forced mow. For now, we take the position that no, that's not an enforcement action, that as long as you comply with the notice requirements of the deed restrictions, and again, keep in mind, you can't force mow somebody's yard unless you have the authority to do so. And anytime you're looking for, do we have the authority to do this, you start with your governing documents, start with your declaration. If it has that authority in there, it typically says you got to give them, for a forced mow, 10 days notice, and send them a letter. And that letter should be sent by certified mail and regular mail. And then after the 10 days runs, you send your contractor out there to mow the yard. For now, we don't think that that's something that has to be, decision has to be made by the board in the open session.
All right. This question is, if a homeowner asks for an ACC appeal to be held in private and does not want the decision to be known, is that something the board can accommodate, or does the decision need to be announced during the open session?
Nobody's ever asked that before. I think that if the owner doesn't want the decision to be known, then you don't have to publicize that. One of the things in the property code about executive session is you can keep communications that a party's request to be confidential, keep those confidential. So I think I would take the position that if the owner doesn't want it known, you can say that there was an ACC appeal hearing and decision was made that's being kept private by request of the owner.
I guess this is a personal follow-up from me. Is that something you'd recommend the board get in writing? Just
Yes,
to have
definitely.
the record?
Definitely have just an email is fine.
All right, here's an example. This collection policy states if an owner's account remains delinquent for a period of 90 days, we confer directly to an attorney. Is that sufficient, or does the amount need to be stated?
I don't think the amount needs to be stated. If that's enough after 90 days. You just have to be able to show that it was delinquent after 90 days. And again, the most conservative advice is, even if you have that language, still turn accounts over in the open session.
All right, last one here, Cliff. Next to the last one, this is an easy one. Where can we find all these codes?
So the property code is available online. If you just type in Texas property code, you'll be able to find it. Typically, the primary chapters that you want to look at is chapter 209 is the primary law. If you're in Harris or Harris and Montgomery, and I think Galveston now, Resort, yeah, chapter 204 of the property code and chapter 202 of the property code. So those are kind of the three chapters of the property code that govern associations. Chapter 202, chapter 204 for certain counties, chapter 209.
And then 82 for condos.
82 for condos. And 81 if you're a condo that was established prior to, I think, January of 1994.
Yep. So last question here. So you would discourage monthly workshops? Can voting be done on items that not in the 15?
I would discourage monthly workshops. And anything that's not on the list of the 15 items, a vote can be taken by email.
All right.
But again, it goes back to, like, if you're going to hire a landscaper, I mean, if that can wait until the next meeting, just wait till the next meeting and do it then. If it's a pool pump that needs to be fixed and the board needs to make a decision, then you got to make that decision. But if it's something that can wait and you can have the vote at the next meeting, the intent of the law is that association business be conducted in the open session of a property notice board meeting. Now, obviously, there has to be some exceptions for that, for things like a broken pool pump or some maintenance issue or some other thing that needs immediate attention. But if it can wait, just wait. And that's to avoid the whole perception that you're doing things not in front of the owners.
Hey, real quick clip. The person that asked about where to find the property code says that they're in Michigan. So I would caution that these are all exclusively Texas laws.
Right.
And do not apply to any other state. So
right.
Michigan will have separate laws that you can look up the same way. Just Google Michigan property code and something will come up. All right, that appears to be it. Just real quick, we are sending out a legislative update on the first session tomorrow, or on the opening of the session. It's going to list all 20-something bills, POA-related bills that have already been filed. So look out for that in your email.
All right, thank you everybody for coming.